founder of Keystone Law Group, Sandeep has been a real estate and personal injury lawyer in the Fraser Valley for over 15 years. Sandeep is an active member of the Law Society of BC and the Trial Lawyers Association of BC. Today, he is going to give us some helpful tips on what to look for when buying an investment property. Let's welcome Sandeep Gill. Hi everybody. Hi everybody. It's like there's a celebrity introduction there. So
I'm blushing.
Thank you, Sandeep, for joining us today. And of course, welcome to everybody joining us on Karista Live. We have Sheila Sampson, your wonderful mortgage strategy manager here at Karista, Carol Cole, mortgage strategy manager here at Karista, yours truly, Bernadette Laxmana, and one of our favorite lawyers, Sandeep Gill. You heard the introduction. I don't need to add anything to that because it was spectacular. Hi, Sandeep.
Hello, Bernadette. Thank you so much for having me today as far as Karista Live is concerned, and thank you very much for the team for the warm introduction.
Beautiful. So Sandeep has been, we've been working with Sandeep for many, many years, has helped a lot of clients. So I'm so glad that you're here today. To all of you who are watching, we don't pay, Sandeep doesn't pay us to be here. We just value his expertise, his knowledge, his wisdom, and really his time to share all the information that he's going to share with you today. But before we proceed toward his presentation, I just want to invite everybody who's joining us today. We have our real estate investing webinar English edition on May the 26th. That's 6:30 to 8:30. It's via Zoom. It's free. So we have the link here. Please feel free to click and register because there's a lot of information, inspiration, strategies that we will be sharing with you on May 26th. So that is free. It's available to you. It's highly in demand. Normally we have it in Tagalog, but a lot of people have been asking for the English edition. So there you go. Due to insistent and persistent public demand, it's for you. So thank you for that. Without further ado, Sandeep has prepared a wonderful presentation for all of us here today. Sandeep, take it away.
Bernadette, thank you very much for that. I'm going to obviously walk through some of the preliminary matters that surround buying an investment property. The focus of my presentation sort of hits on some pitfalls that come along the way, questions that surround property transfer tax, questions that surround GST. All of these have become more poignant and more of an issue in our current climate as far as investors are concerned, because there are so many new properties that people can buy into from an investment perspective, or alternatively, they may be considering making changes from their existing principal residence, moving into a new property, and then converting their old one into their income generating property. So all of these will be very useful tips and pieces of information that our listeners and watchers today can utilize when they're making their decision on an investment property.
And sorry to disturb you, Sandeep. And everybody who's watching today, if at any point you need clarification, you have questions, please type it in, and we will do our best not to rudely interrupt Sandeep and just kind of excuse ourselves and make sure we have the space, the time, and we honor your questions. So please type it in, and we will address them as they come, and Sandeep will pause to give you his time and energy. Thanks, Sandeep.
My pleasure, Bernadette. So one of the first items I wanted to touch base on were pre-sale contracts. So a lot of people may be looking into investing into newer type condominiums, townhome complexes, or something of that nature. And I just wanted to highlight some key matters that you want to be aware of when it comes to entering into these types of contracts. So pre-sales, as you may or may not be aware, deal with properties that aren't ready for occupation or for purchase right at the moment. They're still in the process of being constructed, but developers and marketers will allow you to lock in your contract at potentially a more preferential price point at this point in time versus having to wait until the project was fully complete and maybe buying when the market has gone up, and as it continuously has within the Lower Mainland over the past many years. And it'll allow you to lock in at a better rate. But the things that you need to be aware of are, one, closing dates are never set in stone. So although the developer may have a plan as to when they wish to have the development complete and ready for occupying and ultimately renting out as it relates to an investment property, you don't necessarily know or can guarantee that it's going to be completed on the date that's specified in the contract. So it can move, and you need to be aware of that aspect of things. Increases and decreases in property value. So as I was saying, we in the Lower Mainland have been extremely fortunate. Prices here have continuously year over year increased, and that's both as it relates to condos, townhouses, as well as single family homes. But there's always a potential that those values could drop. Although our current market is going through a bit of a shift. If we use any of our historical indicators, any slight corrections we have are usually short-lived, and we then get back into an appropriate increase in property values as time moves forward. And you have to always think when you're investing, you're not investing necessarily for the short term. You're investing for the long term. And historically, land always goes up in value. It doesn't come downward. There's an old adage: God isn't making any more of it, and so we have to take what we can at this particular point. And for those investors that may be looking into buying in a pre-sale type scenario, for the possibility of flipping this property, gaining a quick increase in value, and assigning that contract, which is basically taking your contract as you've entered into it and passing it on to a different buyer or a new buyer, isn't always possible. And these are things that you want to make sure are discussed with the developer, and you've given yourself that right or ability to do that right at the outset when you're entering into these documents. Property transfer tax and GST, and that's where I wanted to sort of focus the balance of my presentation on before just highlighting some closing comments. When you buy an investment property or you buy into a rental property that you want to ultimately utilize for income purposes, there's always what we call property transfer tax that has to be paid. There are some small exemptions that exist as it relates to it, and one of those exemptions is what we call a new build exemption. So if you're buying a new property, be it a townhouse or a condo, because those are the types of properties that are usually going to fall within the category of an exemption, and that valuation sits at $750,000. Now, our current market, those properties are few and far between, but you may come across them. And if you do, at that particular point, if you decide to move into this new property as your principal residence, the BC government allows you to avoid having to pay property transfer tax. However, you have to continue to live in that property for a minimum of 12 months in order to take the full advantage of that exemption. There is also what we define as a GST credit or a rebate that's available. Under our current climate, I'm not going to spend a great deal of time on GST rebates. The reason is that it is only applicable on a specified price point. That price point is very low. And as of right now, Canada Revenue hasn't changed that. They may in the near future. And the price point that I'm referring to sits at about $350,000. So unless you locked into a contract to buy a place many years ago and it still hasn't completed at this point, you're likely not going to be able to take advantage of it. The new build exemption that I was referring to, as I said, falls into certain categories for you to take advantage of it. And Bernadette and her team will definitely assist when you're making the decision to maybe change your principal residence from your current home into a new one and then start renting out your old property as your rent income generating property. You can take advantage of this new build exemption, but like I said, it has to become your new principal residence, and you have to be below that price point that I referred to at 750,000. And most of these properties where you're talking about that price point are well below the size requirement, which is 1.24 acres in British Columbia. Now, just because you've owned a principal residence in the past doesn't mean you still cannot qualify for this exemption. It still is available. It's not a first-time buyer exemption. That's a different category. But in this particular case, it would be the fact that you're continuing to use this new property as your principal residence. New build GST rebate, as I said, the similar requirements apply when you're going to utilize this. But again, because the price points are so low, it doesn't have much application in our current real estate market as far as BC is concerned. Now, it may be utilizable and could be utilized in properties that you may be looking in other provinces where the real estate markets aren't as hot and price points are more viable. These are considerations that you could utilize or benefit from if you're, say, looking at buying in Alberta, Saskatchewan, or even some of the other provinces across Canada. And bear in mind, the GST is a Canada revenue tax, so it isn't applicable just to British Columbia. You get to take that advantage across Canada. And the valuation as far as the reduction in GST that we're talking about is the 36% as far as the total GST that's payable. Now, there are some pitfalls that you want to be aware of in GST. Now, and in our current climate, in our current real estate market, this has become a more prevalent issue. But there may be scenarios where you're buying into a property as far as an investment property is concerned. However, you're not necessarily buying directly from the developer. You're buying from somebody who may have completed on this new build or this new location, be it a townhouse or a condo. And before they move into it and occupy the home, they decide to sell it and they market it as a new home. What you need to be aware of as a buyer is that GST does still apply in those types of situations. So your purchase price will increase by 5% as far as the GST is concerned when you're not buying that property from a person who's either occupied it or used it in some form. So if you want to be very careful when you're looking at these marketed properties, that if they're being marketed as new, unoccupied, new construction, you always want to be aware of the GST that will apply to your purchase price. And there are methods that your qualified realtor will help you negotiate as far as trying to adjust the purchase price so that you can take the maximum benefit and not have to pay that additional 5% above and beyond any negotiated purchase price that you may have worked on. Some of the other factors to consider as it relates to not necessarily just GST, but generally as it relates to the ownership of your home. Now, in investment situations, and when you're entering into the investment market, you may be looking at bringing on other partners with you. And some of the considerations you want to have in those situations is how you register yourselves as owners on the property. One of those, in British Columbia, there's two methods by which we can do that. One is what's called joint ownership. The other is what we call a tenancy in common. Joint ownership in an investment situation may not necessarily be the best way of going. Whereas tenancy in common allows you to create percentages of ownership as far as your property is concerned. So if you have, say, one partner or two partners that may be buying into an investment property with you, you can control what percentage each of your partners and yourself are going to have as far as an ownership stake is concerned in the property itself. And there's other considerations that we can have when it comes to ultimately taking ownership of the property. as you become more and more involved in the investment industry. And Bernadette and her team have done a number of mortgages for you, and you end up owning 5 or 6 properties down the road. Then you come to talk to someone like myself, and we can get into more advantageous or better ways of owning these properties for you. Now, as I was indicating, for investment properties, some of the considerations where you're not taking advantage of those principal residence type scenarios. So the exemptions we were talking about on GST and the property transfer tax are no longer available to you. So you will be paying those additional amounts as part of your purchase price. So you want to factor that in when you're talking to Bernadette, so they're well aware of these factors. And you're not being caught blindsided at the time of completion and short on funds or whatever the case may be. And I'll describe to you in a bit more detail what I mean by that. But communication with your team members, and that's inclusive of Bernadette and her team. It's inclusive of your legal team that's going to be representing you, but also your real estate team. You want to be communicating as much of that information you can to them. We're here to help you at the end of the day. And the more information you give us and the more clarity you give us regarding what your wishes and desires are on your property ownership, the better we can advise you and point you in the correct direction. I quite often get the question, what are my tax implications as it relates to owning an investment property? So in Canada, we have what's called a capital gains exemption for principal residence. So when you own a home and you live in that home as your principal place of residence, when you sell it in the future, there's no capital gains that you have to pay. The government, luckily enough, lets you walk away tax-free from that transaction. But investment properties, you need to be aware. Ultimately, if you don't convert it to your principal residence, that investment property will generate capital gains for you when you sell in the future. And you always want to be cognizant of that fact. And in British, or at least I should say in Canada, the calculation of capital gains is on 50% of whatever the increase in that value is. And as Bernadette grooms you to become seasoned investors, that type of increase is going to be a great thing. So don't necessarily shy away from it because of that fact. Now, I highlighted this briefly when we started the presentation. Pre-sale contracts are a component of it. But the bottom line, when you buy a property, the foundation of buying that property is based on your contract. And in our current market and the way things have now progressed as far as the real estate industry is concerned, we're now back into a time where the drafting of your contract and the subjects that you enter into that contract, which are essentially your rights and your ability to investigate your investment and make sure it's the right type of property for you to buy, become extremely important. And having a qualified realtor working with you side by side to ensure that your rights are protected when you're buying a property becomes extremely important. Bernadette has in the past had very qualified property inspectors that come and speak quite often. And property inspections are a foundation of when you're buying into an investment property. They allow you to ensure that the property is in good order, that things like roof repairs don't become an issue for you as an investor. Things like hidden defects that may exist as far as mold and mildew and all of that aspect of it. These are the types of subjects that you want to ensure are entered into your contract so that you're not caught blindsided and they're not causing you problems after you become the owner of the home. I can't reiterate the importance of working with an experienced realtor, one that can negotiate the terms of your contract for your maximum benefit, both as it comes to the topics that I'm discussing today as far as GST is concerned, but also as far as these inspections, the right to have appropriate financing ready and available for you, so that Bernadette and her team can do the due diligence and work that they need to do so that you can buy the property. There's subjects that can be put into your contract that ensure you have those rights and availability to protect yourself at the end of the day. Reviewing title becomes a component that, as you've entered into your contract and you move forward with it, becomes important. We want to ensure through the review of your title, and this is a document that not only your realtor is well versed with, but quite often they approach your legal team or your lawyer to review title with you. We want to ensure things like rent restrictions don't exist and aren't registered on the title, so that when you do buy your investment property, you're not limited on your ability to rent it out or lease it out to a tenant at the end of the day. And these are types of things that we will be able to discover through the review of the title itself, but also other viable documents when it comes to the strata and the bylaws that operate within your strata. So we want to ensure that when things move forward, you're having the ability to review that title and all of the required documents that come along with it. As far as my office is concerned, this is a service that we provide to our clients when we're completing transactions and we're ultimately going to be completing on the purchase or the sale of your property. A review of title and appropriate documents is something that we provide as a service. We don't charge anything additional for it or extra for it. It's part of what we do. But we want to ensure that, and quite often your realtor will be reaching out to us in advance, even before you've had a chance to lock in the contract, so that those items are not causing you any problems before you've actually put pen to paper and signed on the dotted line, so to speak. I can't reiterate the importance of communication. This cartoon is a perfect example of what could happen for you if you blindly, without communicating with the likes of your mortgage brokers, your real estate team, as well as your legal team, you're going to be stepping off that edge, not knowing what's going to happen. And the more you're able to tell us as far as information is concerned, the earlier you tell us as far as that information is concerned, the better. You can never pre-plan enough to ensure that when the time comes and the keys are handed over to you as the new owners of your rental property, that you've made the appropriate decision at that time, and all of the bases that can be covered for you as best as possible have happened with the use of that communication at the end of the day. So never shy away from it. Don't be afraid to call us. Don't be afraid to communicate with us and let us know ultimately what you're seeking to do and what your goals are. And now I want to hand it back to Bernadette and her team. If there's questions that may have come up along the way that we didn't get a chance to address, or questions that may have come up since then, please let us know, and I'm happy to answer whatever I can.
Okay, well, thank you so much for that, Sandeep. And we do have some questions that we've experienced in the past. So first of all, we have the contact information for Sandeep there. So if you have legal questions, feel free to reach out to Sandeep. And to all of you who are watching, this is an opportunity for you to ask a lawyer. Come on, like
it's free advice. I'm not charging you for it at this particular time.
Exactly, right? So I'm just like, well, this is a great opportunity. He's not going to bill you for your questions. So I think to all of you who are watching right now, like, hello, take advantage of this opportunity. But I think we have a question that we have here. Sheila, would you like to pose the question, please?
Yes, we do have some questions here, but by the way, Sandeep, I just want to let you know that's a great presentation. It's a complex topic, but you made it very simple to understand. So the first question is, how long can the tenant stay after the lease expires?
So when you enter into what we call a residential tenancy, the residential tenancy can be for a fixed period of time, or it could be what we call month to month. In British Columbia, when a fixed term lease or a fixed term rental comes to an end, it comes to an end. They're technically not entitled to continue living in that property at that particular point. and the tenant must vacate. Now, you need to be careful when you're setting up your agreement that you are setting it up for a fixed term purpose if your goal is to have it empty at some point in the future. If your goal is to keep it occupied as long as possible and continue to have it rented from month to month, then your tenancy agreement is going to be in that nature. It's going to be month to month. And just because the month comes to an end doesn't mean the tenant has to vacate the property at that particular point. They're entitled to continue living in that place so long as they continue to pay the rent on a month-to-month basis. They will be considered a month-to-month tenancy, and that's how the Residential Tenancy Board will govern it. So you want to be very careful. Although fixed-term leases or tenancies are recognized, you want to ensure your agreement is drafted in that way so that it allows you to be able to have the tenant move out if you wanted to do so.
Okay, I have a further question on that. Say I am the landlord, I'm buying this property. Twofold questions. Say I'm buying this property and it's a fixed term contract and I want to kick them out. Can I do that? Is it easy? Or second, if I enter into that contract, if I move into that, to take ownership of the property and it's a month to month, can I kick them out?
So with respect to, let me answer your question sort of in reverse. So when you buy into a property and there's already an existing tenant there, and you're buying the property with the hopes of keeping this particular tenant on, you will be taking that tenant on a month-to-month basis when you take over that property. If your goal is to ensure that that property is vacant and empty, so that you have the choice of deciding who your new tenant is going to be moving forward, there are limitations as to how that works. So you can ask as part of your purchase process to have the seller vacate the property and have it empty for you. However, you can then not re-tenant it or re-rent it for a period of 6 months after you bought the property. If you decide to do that, you can risk the tenant coming back and suing for damages for vacating a property that was just going to then be re-rented again for to a different tenant for possibly different terms or whatever the case may be. So you want to be very careful if that is your goal. Otherwise, you're going to have to essentially occupy the property for a period of 6 months where there will be no rental income coming through. So you want to be very careful in that respect. And sorry, Bernadette, with respect to the first part of your question, you were asking.
Oh yeah, it sounds like what you're saying, whether it's a fixed term or a month to month, you can't just kick them out unless
and
it doesn't matter what kind of term it is.
Correct. So if it's a fixed term lease, you can't just randomly decide before the term is completed that you want to vacate the property. The tenant is entitled to run the term of the lease period, be it 6 months, 12 months, 2 years, whatever the case may be. The tenant is entitled to stay there so long as they're complying with the terms of the fixed term lease. If it is not a fixed term lease, then residential tenancy treats your agreement as a month-to-month tenancy. But that also doesn't give you the right to just say, I want to have the property vacated. You have certain grounds that you can take those steps from. And one of those grounds is that if the tenant isn't following the requirements of the tenancy, they're not paying rent or something of that nature, you can have them evicted. Or alternatively, you can indicate that you wish to use that property for personal use and have it vacated within a 2-month period. However, you lose 1 month's rent in that scenario. And again, if you're giving one of those 2 months evictions due to your own personal use of the property, you have to use it personally again, and you cannot re-rent it for that 6 months.
Okay, well, I'm glad we clarified that. So it's not as straightforward. So I think that's a great lesson. Thank you. And Gilbert has a question here. In order to avoid capital gains tax to sell an investment property, would family members, i.e. parents or kids, stay in the property for a period of a year prior to selling it and still be considered lived in by the owners? That's a good question.
So it just because you're moving a family member into a property doesn't convert that property into a principal residence for yourself as the owner. So it is the actual registered owner of the property that has to convert that location into their principal residence to avoid the capital gains. Strictly moving family members into it doesn't achieve that goal. It will continue to remain an investment property for you. The only way that would change is if you actually make that new location your principal residence and live in it as such.
Very good question, Gilbert. So thank you. Next question, please, Carol. Oh, I couldn't hear you. Sorry.
Hello, can you hear us?
Yes.
Can you hear me? Okay, good. So good afternoon, everyone. The afternoon has come to tell you that half your day is done. So I hope you're enjoying afternoon. Okay, so thank you for that wonderful answers, Sandeep. So the next question for you is, what are the most common lease violations?
Sorry, what are the most common lease
Violations.
So the most common one from a tenant standpoint would be non-payment of rent. That is the most common violation that exists. And luckily enough, the Residential Tenancy Board, although commonly favors the tenant, in this scenario does give the landlord the ability to have a tenant vacated relatively quickly, and the notice periods are quite small. So if a tenant doesn't pay you at the time that they should, depending on how your agreement is set up, which may be the first of the month or whatever the case may be, you can very quickly give a notice for non-payment of rent and have the tenant vacated. Other common violations would include if your lease agreement had stipulations on pets being on the rental property, smoking. Those are all categories of common violations that quite often happen. And again, if those are violations that occur, you can relatively quickly provide the tenant notice for vacating, for violating those requirements of your lease agreement or rental agreement. And then the other category of violations fall into more risk-based violations, where the tenant may either be a danger to the property, maybe a danger to other tenants. So say your location is a multiple tenanted property. If that individual becomes a danger or a harm to other existing tenants or residents of the property, you're able to take steps to have them vacated as a risk or a danger risk. And those are probably the areas that you would best cover off.
Okay.
Well, I'm glad we're talking about violation. I had a client, and I want to share this to all of you who have tenants. So I have a client who did not have a property manager, and this tenant vacated, and they pretty much didn't do a good job maintaining the property. So obviously the landlord did not provide the deposit, right? Kept the deposit. Again, this landlord did not have a property manager, right? So needless to say, did not pay, whatever. And then the tenant came back. Apparently there's a law that if you're not going to give back the deposit, you have to give it to them in writing within 30 days of them vacating. But because this landlord did not provide the letter, they missed the window. So by law, the landlord had to pay the deposit, even if the tenant really did not take care of the property and the landlord had to do repairs. So that's a really something that violation that your tenant can easily do. So please bear that in mind and learn from this landlord's lesson. So
the use of a property manager, unless you're very well versed with the Residential Tenancy Act and the regulations that govern the Residential Tenancy Board, the need to have a property manager is vital, because almost everything that relates to a rental property or a leasehold property for you is all governed by notices. If you're not giving notices when they should be given and on the appropriate occasion, you're going to run the risk that a tenant is going to make a claim for a dispute with the Residential Tenancy Board. And they, as I indicated, the board tends to side in favor of the tenant. Is just the way our system operates, and they will award a tenant a damage deposit if the notice wasn't given, even though the property was damaged and there was harm made to it. That may not necessarily convince the adjudicator to decide in favor of the landlord. So these are all risks that can be mitigated by having a property manager help you.
Oh, thank you. Thank you. Sheila, next question, please.
I think Caroline has a follow-up question. Do you have a follow-up
Yeah,
question?
I have a follow-up question, Sandeep.
Sure.
If ever that you already give the 2 months notice to the tenants and they still don't vacate the property, what's the next protocol or steps for them to
Yes.
follow?
So if you've appropriately given notice, time periods have lapsed, and there's been no dispute filed by the tenant, but 2 months come around and they still don't move out, then at that particular point, you have the ability to apply to the Residential Tenancy Board. Although it doesn't happen extremely quickly, you have the right to apply to them to have the tenant forcefully evicted from the property. Once you obtain what we refer to as an order for possession, you will then take that order. It will be converted into an official Supreme Court order, and then you hand the matter over to a bailiff who will walk in, change the locks, and remove the tenant's belongings. So although it feels scary and there's a lot of complications involved with it, there are rights and remedies that are available to you. It's just that it takes time, and you want to ensure that you're taking those steps when they should happen as quickly as possible.
Great.
Thank you. And it's good to know it's not really happening a lot. Yeah.
Yeah, so the next question will be, what happened if a tenant breaches the contract?
So the number one thing that you want to do if a breach has happened, now you obviously want to make inquiries as to what the nature of the breach is. Is it serious enough where you want to actually consider evicting the tenant out? Maybe they've been a good tenant. Maybe they are still a viable tenant that you want to keep on the property. So you want to make those considerations before you necessarily give them an eviction notice to move out. There are methods where you can give them rent distress or periods of time where you can abate the rent or have it paid over a period of time. So you want to factor those things in when you're making your decision. But if the choice is you're not happy with the tenant, you no longer want them, they've breached your agreement, step one is to give them notice to evict the property for the appropriate reason, whatever the case may be. If it's non-payment of rent, there's a specific notice for that. If it's danger, there's a specific notice for that. So that's step number one, and then you go from there.
Okay. Thanks, Sandeep.
Sounds like you have to make sure it's documented each time, whatever that is, though.
And beyond just the documentation aspect of it, almost in all scenarios, you want to have the process witnessed. So very often, my recommendation to my clients will be that, okay, if you're posting a notice to a tenant, have someone along who's independent or maybe a third party. It could be a neighbor or whatever the case may be, who witnesses you having those documents posted on the door or handed to the tenant, because it's not uncommon that a tenant will argue, I never got the notice, or it was never given to me. And it's always useful to have that additional witness available to you to prove that that step did actually occur.
Good tips. There you go, guys. Lots of tips happening here. Thanks, Sandeep.
Yes. And next question, can landlord terminate tenancy agreement early?
Early is probably a bit of a misnomer. You technically can't. If you're operating month to month, you can't just decide, I want to have the tenant evicted. There has to be a basis and a grounds for the reasons why you're evicting the tenant. If you're operating on a fixed term lease, the answer again is no. You can't decide, say, 6 months through a 1-year rental policy or lease policy that you want the tenant removed. The only way that could occur is you can approach the tenant and advise them that you wish to bring the fixed term lease to an end. If they agree, again, it would be documented and put in writing, and then you would be able to have the tenant leave prior to the end of the term. But in most cases, you have, if there's no cause and there's no reason for why the eviction is occurring, you can't bring it to an end early.
There you go. Well, those are those are great answers, great questions. Do you have any follow-up questions, Sheila and Carol?
We're good.
No?
Good.
Okay, great. So now this is the part where another part that I enjoy. I'd like to invite Carol. I have a lot of notes here as to from Sandeep's presentation that I think are great takeaways, and I want to invite Carol. Carol, do you have key takeaways that people are watching here can take from the presentation today?
I think with Sandeep's presentation, like what Sheila mentioned a while ago, it's a very straightforward, and he really simplified the presentation. And I think the biggest takeaway that I have here in my notes here is creating your Dmdm, like working with an expert. It will really help you a lot because, like what every slides that what Sandeep mentioning or providing a while ago to us is the importance of having your own mortgage broker. It will guide you to a proper financing strategy. And having a realtor will give you a due diligence when it comes to purchase contract. And having a lawyer will have you a person that can discuss you what type of investment you can have with a co-applicant or with a co-investment, like if it's a joint tenancy, right? And having a house inspector, it's also going to be a big help for you guys to have. And having an insurance agent or insurance broker will help you to be protected when it comes to investment if there's any challenge along the way that you have to meet. And of course, having also a property manager in handling most of your property investments.
Thank you, Carol. Sheila?
For me, yes, Carol and pretty sum up everything, but I really love the last slide of Sandeep. My biggest takeaway is the communication. Because, yeah, you're correct, Carol. When you're working with a team of experts like Sandeep, it will be very helpful for us to understand the complex process of real estate investing. And we have to inject also that you have to do your own due diligence and ask questions because from there you will learn a lot and you will be able to answer all the team of experts will be able to answer all that question so you will be having a smooth investment. So there you go.
Thank
Communication,
you,
guys.
Sheila. And anybody here watching, we have 33 people online right now. If you have any questions, please, this is again an opportunity to ask a legal expert without having to pay thousands of dollars. So take advantage of that. Gilbert here is taking advantage of this moment. If an eviction notice is sent due to late payment of rent, but the tenant pays it within 10 days of the notice, the eviction notice becomes void. If there is a pattern of late payment, is there a minimum number of eviction notices sent over a period of a year before the tenant can be legally evicted? Good question, actually.
Yeah, great question. The short answer to the question is there's no minimum number of notices that are necessary. If there exists a pattern of non-payment, you can still apply to the Residential Tenancy Board to have the tenant evicted due to non-payment of rent because they have a pattern of them not paying. Obviously, if there's one occasion of it, the Residential Tenancy Board will likely not decide in your favor. But however, if over the span of the 12 months, if they've missed 4 payments of rent on a consistent, regular basis, and then just pay it 10 days later, 12 days later, or whatever the case may be, you will have viable grounds to still bring on a hearing in front of the Residential Tenancy Board to have that tenant evicted. And there's a good likelihood that the Residential Tenancy Board will uphold your eviction notice despite the fact that the payment has still been made.
There you go. I think based on that strategy, try instead of not. And when as long as it's documented and you have all of that, then you have a shot. So there you go. As long as it's documented and you have witnesses.
Correct.
And it's a pattern. Oh, we have another question. Thank you, Julius. The question is, first of all, thank you, Gilbert, for that question. And Julius, if the house gets flooded and the tenant's furniture got damaged, does the home insurance of the landlord cover the damages for the tenant?
No, the landlord's insurance is not responsible for damage to the tenant. It is a tenant's own responsibility to ensure that their own belongings are protected through a contents policy. The landlord's insurance policy, unless the landlord has specifically obtained a special rider on their insurance that allows them to make such a claim, the landlord is not under a responsibility to cover the tenant's belongings and contents.
Thank you, Sandeep. Julius, I love this question because a lot of landlords forget how important it is to have landlord insurance on the property, especially if it's a condo or strata. So this is a very good question here to reinforce that the importance of that. So any questions, guys, please type it in. But this is the part that, based on what I learned from Sandeep today, the key things that I wanted to share, the key takeaways, all about strategy. I just love coming up with the strategy. So one of the strategies that Sandeep has mentioned was when you're purchasing a pre-sale property, a lot of you think that it's an automatic increase in value over time. Sandeep has mentioned that there is a possibility of a decrease. So when you come up with a strategy of doing this, just make sure you have the possibility of the decrease in price and be prepared for that, because we've had multiple occasions in the past that by the time completion comes, the property value is probably 50 to 100,000 below. I had an example, like 300,000 below than what they paid for. So don't just block off that possibility that the price will be lower when you complete. As a strategy, make sure you prepare for that contingency. So there's that. And also, he also mentioned that when you are investing, this is a long-term game. It's not a short-term. They're not making land anymore. So please make sure you bear that in mind. Another strategy that Sandeep has mentioned is a lot of you, when you're investing, you're automatically thinking, I'm purchasing a rental property and I'm staying in my owner-occupied. What Sandeep has mentioned was you could purchase an owner-occupied, and if it is a brand new property, if it's 750 below, if it still exists, you are exempt from paying the property transfer tax. So that is a strategy. Don't just think I'm buying a rental. You could be I'm buying an owner-occupied and renting out my current. And a lot of times that strategy creates better cash flow because the property that you're leaving will have a lesser mortgage and then bigger income coming in. And most of the time it will cover both what you're buying as an owner-occupied and then the rental coming in on that one. So that was a great strategy. And then the other thing is every time it's brand new, just make sure you remember to budget for the possibility of a GST instead of thinking that whatever that price is you're paying, that's it. Ask about the GST every single time because some people think that that is the price and not budget for that. And another thing that Sandeep has mentioned is, especially in this market, buying with partners. So a lot of times the property, as it goes up, the income that you have as husband and wife will not be enough. And it may be time for you to buy with a partner. And a lot of you would say, oh my God, there's fighting and all of that stuff. There will be fighting if it's not set up properly. And Sandeep has been very good in helping a lot of people purchase together partners and, like what he mentioned, tenancy in common to make sure each partner's interest is well protected. And Sandeep has always said, prepare that contract like a prenup while you're still in the honeymoon stage, while everything is rosy. So see the lawyer about that to protect everybody's interest. And then one of the things that I also value, Sandeep, I've never heard this before, but in my 20 years, but you actually said it right. Subjects pertains to your rights. I didn't even think about that.
They are.
Subject, right?
People forget your contract, that contract that you're signing off on. It's those subjects that are protecting your rights at the end of the day.
Correct.
It's ensuring that if something goes wrong, you've created the foundation to be either able to make a claim if you have to, or not even move forward with the deal because it's not the right deal for you. And people forget that, and we very our market has sort of forced it, but people blindly enter into these subject-free contracts, but they're giving up a lot of those rights, and
Correct.
not
Thanks,
a
Sandeep.
good thing to go
That
along.
was perfect. So now when we talk to the clients, we can honestly say, if you go subject free, you're pretty much giving up your rights. Like it's like
Yes.
we don't have to give an elaborate explanation. That's what you're doing with subject free. So there is that. So that was a very great. I put a heart and a star on that one. That was a great takeaway right there. So I value that. And then the other strategy that you had mentioned is reviewing title. A lot of lawyers don't offer that. A lot of lawyers will just work with you when you've signed a contract, remove subjects and closing date. But the value that we get from that, Sandeep, is immense. So basically what it means, people, is when you sign a contract, even though you're in the middle of due diligence, you haven't removed subjects yet, Sandeep is more than happy to go over that with you to make sure that you remember to dot your I's, cross your T's, whatever it is, legal stuff that he can protect you from. He can talk to you before you remove subjects, not go to him after, and it's all said and done. So those are my key takeaways from today. And during that wonderful breakdown that I gave, a few more questions came up. So it looks like we're not closing off yet. We want to help these people. So Sandeep, please stay on. And the question was, it was mentioned earlier that joint ownership is not the best option. Tenancy in common would be preferred way. Can you elaborate why one is better than the other? So again, Sandeep, maybe you can explain the joint is for spouses and.
Sure. It's not that joint tenancy may not be the better option. There are times where joint tenancy is the better option, but investment properties where you may have multiple investors or you're bringing on partners into the transaction, joint tenancy usually isn't the best route. And the reason is, joint tenancy creates what we call a right of survivorship, meaning if one person was to pass away or to pass on, the surviving person becomes the 100% owner of that property. And unless you've either created documents in the background to protect yourself, what it will mean is your partner that you either went in on 50-50 at or whatever percentage you've agreed at now owns 100% of that property. And they don't necessarily have to share it if they don't want to. And that's where, as Bernadette was saying, you want these agreements drafted and put into place if you haven't already done so, when everything is rosy and happy between parties, because you're usually going to be on the same page when you're agreeing and signing off on documents. That's why tenancy in common allows for you to set a percentage of ownership. And just because you've passed on or something happens to you into the future doesn't mean you've lost that percentage. It will remain with you and your estate so that your family and loved ones can continue to benefit from that ownership that you created.
So if I could explain it like a grade fiver. So let's say Peter and Maria get married and they buy a property. Peter passes on. Maria takes ownership of the property 100% if they're joint. So that
Correct.
works because they're married and they have kids and you want that. In the meantime, Peter enters into a purchase contract with another party. Peter, Paul, and John bought a property together. So if they bought a property as joint ownership, then what's going to happen is Peter passes on. His interest, 33% goes to those people. The wife doesn't get anything because that's the contract that he's entered. But if they entered into a tenant in common, making sure the terms are right, then Peter's interest will go to the wife. Because that's what the agreement was. So I hope that clarifies that. The joint ownership has its place. When you have partners buying rental properties together, it has its place. So did I explain that right?
Yeah, no, that's exactly right. As a husband and wife, even if you're buying an income property or an investment property, joint tenancy is still a great way to, it's the way you want to go. You don't want that property tied up in estate planning and probate and all of that aspect of it. It's a great tool. It's just when your investing partner isn't necessarily your spouse, or even a family member. There may be times where a family member may be still a viable way of going about it. But when it's a bit more of a business transaction that you're getting into with partners, then tenancy in common becomes a better option.
Okay, great question there, Gilbert. He's really thinking it through, like paying attention to the details. So thank you. MJ has a question. Hello, everyone. What if a landlord wants to increase rent? Ooh, this is a good question. In accordance with the law, but the tenant does not comply. Will that be also considered breach and will result to eviction or vacate the place? What about the renter's rights? Ooh, this is a juicy one.
Yes. So, by law, a landlord is entitled to the statutory increase of rent on a year in, year out basis. You have to bear in mind it is a very small amount, and usually doesn't justify the ruffling of the feathers that it may cause. Even if it was a number of years that you didn't increase the rent, even if you decided to do so, 4 or 5 years later, it may only amount to $50 or $60 type of idea. So, by right, landlord can ask for a statutory increase in the rent. If a tenant refuses to do so, you can create the grounds for an eviction for a breach of the agreement, because by law you're entitled to that rental increase.
Yeah, so in BC, I think we're allowed to increase it only by 1.5%, regardless of how long the tenant has been there. And
Correct.
also, I was told, I think, like Sandeep, that you have to give like 3 months notice or something. You can't just do it next month.
No, you have to give the appropriate notice. Once the notice is provided, the tenant will then comply with it. And you are correct. I believe the timeline is 90 days that has to be given to them. And then they if they're going to comply, they should pay the increased amount after that time frame. If they fail to do so, you can pay or give them a notice for eviction for non-payment of rent.
There you go. So a lot of these questions to some of you may feel that this is heavy. This is a lot of details. This is a lot to remember. Sometimes, like when it's new to you, it could sound like that. And I promise you, with the gains, with the increase in your net worth, it's all worth it. And also, the best way to approach all of these things is a wonderful opportunity to learn. It's an adventure. It's a journey. So there's that. Julius has another question. Is a rent to own also be considered an option in buying a house, then saving and wait before purchasing? What's the pros and cons of a rent to own? So I'll have you take care of that, Sandeep, from a legal standpoint, and then we can answer from from a mortgage standpoint after.
So an option to purchase or a rent to own is a method by which you can secure a property today at a specified amount, and then complete on that transaction at a future point in time. Your payments that you make towards that rental property will ultimately go towards your purchase price. So it's essentially considered a long-term contract to buy a property. That's really what a rent to own is. However, you have to bear in mind, unless you register that rent to own agreement against title, that property could still be sold to somebody else if you haven't appropriately protected your rights and done that process with the correct legal processes or steps, for lack of a better term. Rent to own agreements and options to purchase are registrable charges. They can secure a property so that it can't be sold out from under you while you're waiting to complete on your transaction. If you fail to do that, the landlord may decide that they're just going to sell it to somebody else, and you could be out of luck. So they're definitely usable options. They're not used extremely often in British Columbia. They're not a very common tool. I'm not going to say that they're not used at all, but more often than not, conventional rentals are the way that they go. It is your rent-to-owns are more advantageous for people who have lived in a property for a really extended, long period of time. This is the home that they want to buy, and if they can reach the appropriate terms on price and timing with the landlord, it's a good tool to use.
Yeah, and we've had experiences when, I love what Sandeep said, it has to be done properly, because we've had instances where somebody entered into a rent-to-own, right, Sheila, and it wasn't done legally, correctly, and it was, we had a heck of a time getting a mortgage for that one. So
Disaster.
Yes, so it's very, very important that the contract is really vetted. It's done through by a lawyer, and dot your I's and cross your T's. So that's a great question. I think we've answered all your questions, and I think there's a few things. There's one more question. Oh, okay. Regarding the rent increase, if the term is fixed tenancy, can the landlord terminate the lease at the end of the term with a proper notice? Then the rent is out a higher rental amount to a new tenant. Ooh, that's a good one.
Yeah. So on a fixed term lease, when the term is complete, the tenant is required to vacate the property. And at the end of the term, if you've given the notice, once you've given the notice and the property is vacated, you are then free to rent that property out to the next person. And it'll be a new contract. It'll be new rental terms that you set up that agreement with moving forward.
Okay, so if I hear you right, if I have a 1 year and it's completing June 30th, how much notice do I tell the tenant that they need to vacate by June? 2 months before?
Yes, you would want to be required to give them the standard 2 months that the term is coming to an end, and that they will be vacating the property at the end of the term.
Okay, so they vacate June 30th, and you could rent that July 1st, no problem.
Correct.
Even if it's not personal use. Oh, that's a good one. That's a good one. Thank you for that.
It's not governed by your personal use or anything of that nature. It's just the nature of what your rental was for that property with that tenant. It completed at the end of that term.
Josie, that's a very good question right there. That's an awesome strategy, because every year when you keep the same tenant, it's worse. Every year the tenant is much higher. So that's a good question. I learned something new there. There you go. I think we have those wonderful questions. I think there's something else that we need to mention here, Carol. Oh, you're muted.
I just want to share what my father's advice to me. His name is Warren Buffet. So
Disclaimer.
so he mentioned that the best investment that you can make is an investment in yourself. And the more you learn, the more you earn. So that's why, due to the insistent public demand, we are offering an English edition of our free real estate investing webinar on May 26, 2022, and that will be next Thursday, and it's going to be 6:30 to 8:30 p.m. So you can click the link there, so you can share that link to your friends, so all of you guys will all learn together regarding real estate investor.
Sheila?
And if you enjoy the discussion today, please join us next time, Wednesday, May 18, same time, same channel, with a real estate expert speaker from Greater Vancouver, Kamloops, and Alberta. See you there.
There you go. And please follow us on social media. We have a lot of information we share here. Please follow us on social media. We constantly give you inspiration, information, strategies online. So please follow us there. And we have some question here again. So Josie said, what if the existing tenant doesn't want to leave at the end of a year, but they agree to a higher rent the second year? Is it allowed?
It is, as long as the parties have agreed, and it is again documented and set up for the next term. You're allowed to the rental increase. It's something that you've mutually agreed upon, and you can move forward with securing the second term if you wish to do so.
Oh wow. Okay. Well, that's good to know. And then we have something like Sandeep doesn't know this. Sandeep, thank you for being here today. You are a valued partner by Karista. Thank you for going above and beyond for taking care of our clients. We love working with you. And I know something is happening on Friday, and we just wanted to share this with you. So Friday, Sandeep is turning 22.
Wow.
How did you guess? It's incredible.
I thought you're just 19.
Sorry, I made you older there, Sandeep. So,
Oh, sorry.
many happy, wonderful, joyful returns. I hope you enjoy your birthday, and we really enjoy being one of your key partners. We appreciate you. All of you here who, again, would like the expertise of a wonderful legal expert, we have the contact information here for Sandeep. Feel free to reach out to him for any legal advice. And if you are interested in exploring your options in purchasing a rental property, become a real estate investor, please book a discovery quick call with your mortgage strategy managers, and they're going to help you identify your goals, your dreams, and then create a strategy to make your dreams come true. Thank you, everybody, for joining us today. We appreciate you. Have a great hump day, the rest of your day, and enjoy again, Sandeep. Thank you so much.
Bye. Happy birthday.
Bernadette,
Thank
thank you so much
you.
for
Thanks.